We do a lot of High Court injunctive relief work at Constantine Law, and in this short video I'm going to tell you how best to get an injunction in the High Court. This is the mainstay of the work that Caroline Glacken and I do at Constantine Law. We've acted for a number of clients over recent years to obtain highly effective interim injunctive remedies. In general, in recent years there's been a tendency towards the enforcement of employment contracts by way of injunctions in the High Court in London. In the first instance, one would collate the evidence in order to write that down in a very detailed letter of claim and send that to the potential defendants, often they're either current or former employee or employees plural, and ask them to account for their actions. And what you're looking for there is a very detailed response to a very strongly worded letter. At the end of that letter, there will be a request for undertakings. Undertakings are contractual promises in which either current or former employees promise to abide by the contractual obligations in their contract of employment. And if they're given, that might be sufficient for the employer, but they will have to be rigorously policed. Often, undertakings are not given by the employees, or if they are given, they're given in a way that the employer, our client, doesn't fully believe the employee, with the result that they ask that those undertakings are given to the court. If that happens, then an application to the High Court will be necessary. In that instance, we will prepare the necessary paperwork, we will work with leading barristers in so doing, we will speak to the directors of our client and prepare a very detailed witness statement and submit all of that documentation to the court. Typically, the defendant then gets 4 clear days' notice in which they have to attend an interim hearing. The point of that hearing is to decide whether an injunction should be granted. The purpose of an injunction is an interim remedy until the full trial of the matter. More often than not these days, an injunction may be granted because a High Court judge may think that it is in the balance of convenience that an injunction be granted, because that holds the ring in preserving the employment contract until trial. The claimant, our client in this instance, has to persuade the judge that there is a serious issue to be tried. But if they can do that, then in most cases an injunction will be granted. What they won't do at that interim application is hear all of the evidence. They won't discuss issues such as whether there's been a repudiatory breach of contract, for example. It's a highly effective remedy because if the interim injunction is granted, then the case is then set down for a full trial of the merits in a number of months' time. The costs of proceeding from the interim injunction stage to the full trial are often ruinous, which means that the interim injunction, which is a quick and dirty and effective remedy, is often definitive. As a result of which, we have achieved highly effective solutions for our clients in a number of instances in recent years, and they have been able to protect their legitimate business interest and move on with their businesses.